Welcome to this episode of Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers, where we share practical family law insights for people navigating separation, parenting and property matters. Today we're talking about the first steps after separation in Victoria and what to do in the weeks that matter most, including the time limits that can close off your options if you miss them. Separation doesn't usually come with a clear plan. Whether the decision was yours, your partner's, or one you reached together, the weeks and months that follow carry real legal consequences that most people don't see coming. I've had countless first conversations with clients who made decisions in those early weeks about finances, about the house, about arrangements with the children, without understanding what they were actually agreeing to. And by the time they came to us, some of those decisions were very difficult to undo. The first thing to understand is the date of separation. In Australian family law, this is more than a milestone. It's a legal reference point with real consequences. For de facto couples, it starts a 2-year window within which property applications must generally be made. After that window closes, the ability to seek property orders can be lost, unless the court is satisfied that exceptional circumstances apply. That is a hard limit in practice, and it catches people who assumed there was no urgency. For married couples, the date of separation starts the 12-month period required before a divorce application can be made. And once the divorce is finalised, there's a further 12-month window in which property applications must be made. Documenting the date, even informally through a message or an email, is one of the most protective things you can do early on. It protects you against disputes about when the separation actually occurred. The second area is financial rights. The period after separation can feel like a moment to resolve things quickly. That instinct is understandable, but informal financial arrangements made without legal advice, verbal understandings about who keeps what, who stays in the house, who pays which debt, are not legally binding, and they can be very difficult to change later. Both parties to a property settlement have financial disclosure obligations. The earlier you understand what's in the pool, bank accounts, superannuation, business interests, property, liabilities, the better placed you are to protect your position. I'd also say gather your own financial records early. Statements, superannuation balances, property documents. Even if formal proceedings aren't on the horizon, understanding your own financial position is a foundation for every decision that follows. If you and your former partner have children, their care arrangements need to be addressed. The governing principle in Australian family law is the best interests of the children. There is no automatic presumption of equal time. Parenting arrangements can be informal, recorded in a parenting plan, or formalised through consent orders approved by the Federal Circuit and Family Court of Australia. A parenting plan is written, but it's not court enforceable. Consent orders are legally binding. Understanding the difference and which option is appropriate for your circumstances is an important early conversation. Beyond the formal legal steps, a few practical things are worth attending to early. Consider joint credit facilities. Joint accounts and credit cards can continue to accumulate liabilities after separation. The right approach depends on your specific situation and should be taken with legal advice because unilateral action on joint finances can be viewed unfavourably in later proceedings. Review your estate planning documents. In Victoria, separation affects certain aspects of a will, but it doesn't automatically revoke it. Superannuation beneficiary nominations and life insurance policies are also worth a review as part of your broader legal picture. The single most important thing I want people to take from today's episode is this. Getting legal advice early does not mean going to court. It means understanding your options and keeping them open. Approximately 90% of the matters we support through mediation at Village Family Lawyers resolve without court proceedings. That outcome begins with understanding your position clearly and early. Village Family Lawyers offers a free 15-minute discovery call as a starting point. And from there, an initial consultation gives you clear advice on what applies to your situation, what time limits are relevant, and a practical action plan for the path ahead. You can book at villagefamilylawyers.com.au or call 1300413997. The full article is in the episode notes. This has been Divorce, Parenting and Property Matters. Legal Insights by Village Family Lawyers. Thank you for listening.